want to take a minute and look at how the courts have actually functioned in the real world throughout the course of our history. We talked a lot about John Marshall, both last year in U.S. history and this year in government, going back to all the way to Marbury versus Madison, where the idea that the courts have judicial review is established. If you don't remember Marbury, you need to go back and look at that case. And this is where the courts first became a major player in American history. I also think it's useful to divide our American history generally and our legal history into three periods. And those periods all involve an essential question. In the first period of our history, which runs from the founding of the country up until 1870 or so, 65 or 70, the essential question was, what is the role and how much power does the federal government have, and what is the role and how much power do the state governments have? And this is really what Marshall was dealing with. Of course, he believed in a very powerful federal government. Now, the Civil War came along and settled this issue once and for all, particularly with the 14th Amendment, which applied due process and equal protection to the states as well as the federal government. But if you look at the key cases from that first period of our history, this is what they deal with: federalism. What are its limits? What are its boundaries? And John Marshall is the giant figure during this period. The second period, the question is, it deals with minority rights. Well, actually, I'm sorry. There's four periods. The second period actually deals with the role of corporations in our nation, and this is the period from the end of the Civil War up until the Great Depression. And the question here is how much power do corporations have versus how much power do workers have? And quite frankly, the court usually sided with the corporations. We have an amazing 1890s case here where a clerk puts a note into a Supreme Court decision saying that corporations are people, for example, which is going to end up having major long-term ramifications down the road. The third period in our legal history, our great judicial history, is from the Great Depression, I would argue, until maybe the election of Barack Obama. And the question here is about minority rights. I should mention the 9 old men. When FDR tried to reform essentially our economic system, he was blocked originally by the Supreme Court justices who had been appointed by earlier presidents and who were fairly old in age, of course, and did not like his New Deal programs. They were declaring a number of them unconstitutional: the Agricultural Adjustment Act, the National Industrial Relief Act. And Roosevelt, frustrated that this pro-corporate Supreme Court was stopping him from reforming the economy, as you probably remember, proposed legislation to pack the court. He wanted to put 14 justices on the court, or 15 justices on the court. Now, this proved very unpopular, but it did get the Supreme Court's attention, and they changed the way they began to make their rulings. And this marks a major turning away from a fairly pro-corporate court into a court that was more pliable to Roosevelt. The next great question, which will be dealt with primarily by the Warren Court, will be issues about race and the rights of the accused, which is also about race, because the people who end up being accused of crimes are overwhelmingly minorities in this country. And this is going to deal with cases like Brown versus Board of Education, which of course desegregates schools, Gideon v. Wainwright, which we talked about before, Miranda v. Arizona, Mecklenburg County, Charlotte-Mecklenburg County, which deals with school busing. And it will be during this time that we establish that, yes, the federal government has a role to play in protecting the rights of minorities, whether they be doing something like trying to go to school or be on death row. And this will be the third great question in American legal history that the courts will deal with. I should mention that beginning with about the Nixon administration and the Burger Court, the court moved away from that towards a more conservative approach and began to limit things like affirmative action programs and issues like that. We talked about Bakke v. California earlier in class. The Rehnquist Court would be, of course, even more conservative. I think we've entered into a new period, and I don't know how yet to define that question, because I think we're just beginning into this period. I don't want to say it's post-racial America, because I don't want to pretend that all of our racial problems are solved or behind us. But I do think that we have returned to more economic questions about things like corporations versus labor and things like that. And it'll be interesting to see what kind of decisions come out of this new period that will shape the course that America takes, or at least I'm interested to see. You may not be. The courts are not very democratic. They're not elected. They're appointed by the president and approved by the Senate, as we know. They're difficult to remove. If judges go rogue and begin to do things that people don't want, we're just kind of stuck with them. In fact, Clarence Thomas has recently come under a lot of fire because his wife is taking hundreds of thousands of dollars a year from interest groups, and people are arguing that that's a conflict of interest because, you know, they're husband and wife. That money goes into the same household. Thomas and his supporters are claiming that, no, it's completely different. If they give my wife money, that's not like giving me money. But there's not much anyone can do unless they want to try to impeach him. The courts often reflect popular majorities. And they're also a way that the president's legacy continues on after he's gone. I mean, everybody knows about FDR and how he dealt with the Great Depression and his role in World War II, regardless of how you feel about those things. But what a lot of people don't realize is that the civil rights movement is also a legacy of FDR, because a lot of those key decisions that allowed that to happen were made by justices FDR had put on the court. So it's really remarkable to understand the influence of FDR. If you're president for 12 years, you put a lot of justices on the court. And so FDR and then Truman as vice president will shape the court that will be instrumental in the civil rights movement later. And right now we're still living in the shadow of Reagan and Clinton and Bush through their, particularly Reagan and the two Bushes, through their Supreme Court appointments, since conservatives still control the court. Groups are likely to use the court when other methods fail, which is a kind of pluralism. If I can't get my way by going through Congress or trying to influence the president, maybe I can win a court case. But there are still conflicting rulings that lead to deadlock and inconsistency. And of course, rulings are being made all the time that are very controversial. Citizens United is probably the most controversial of the recent rulings. Although Roe v. Wade, which I haven't even mentioned this whole time, is probably the ruling that's sitting out there right now that causes the most controversy. What courts should do, the scope of judicial power. Judicial restraint. Many people believe that judges should play a minimal policy-making role, that judges should, this is judicial restraint or constructivism, that judges should not overturn what has come before, and judges should be very hesitant to maybe declare things unconstitutional. Others argue that at times judges should make bold policy decisions. Roe v. Wade, I would argue, is perhaps the most activist court decision in history, as it literally wrote a law determining trimesters and under what conditions a woman could seek an abortion. That was a really specific, detailed decision and exhibited a high degree of activism, whether you agree with the decision or not. Of course, there are political questions. Somehow, I mentioned earlier the Newdow case, where the Supreme Court did not want to touch the under God and the Pledge of Allegiance issue. And so sometimes it becomes very political, as the court is really seeking to avoid wading into political waters. Or sometimes they choose to wade in those political waters. Bush v. Gore, arguably the most political Supreme Court decision in all of history. All right. Here we see how many times the Supreme Court has thrown out an act of Congress as unconstitutional. You'll notice, interestingly enough, we talk about Marbury v. Madison, which is the first time this happens under Marshall. But you'll notice it only happened one other time before the Civil War. There are exactly two instances where the Supreme Court ruled something unconstitutional pre-Civil War. Although you see it's happened quite a bit since then. You see the New Deal period there, the 14 there, that's FDR's New Deal program. And then you see the period 1953 to 1969. That's largely civil rights and them throwing out civil rights and rights of the accused statutes. And it's become a lot more common to throw things out as unconstitutional. Anyway, here's a little summary for you, and that's what I have to say about the courts.